Hello and welcome back to part 3, topic 10. And we're going to look at the AFP Commissioner's appeal against Justice White's 2009 ruling to the full court. So that's the federal court. So we were just talking about, weren't we, whether you felt the omission of the word mobile phone was a gap in 2001, but a bit strange in 2009 that if that's what Parliament intended, or the bill was aimed at, then why did it not say so? All right, so we've got Commissioner, as I say, he's now appealing Justice White's decision to the full court of the federal court. There's the Federal Justice Building in Adelaide pictured there. We've got Justices Bizanco, Wigney and Abraham, and there's a link there to the appeal judgment in March 2021. And on the privilege against self-incrimination, the primary judge held, after referring to, we've got Sorby and Reid and Howard. So we looked at Reid and Howard earlier in the lecture, didn't we? Although the abrogation of the privilege in this case was indirect, it was nevertheless an abrogation. And see also the 2018 interlocutory hearing there of Lupino and Fisher. The Commissioner says the full court did not challenge the conclusion that 3LA abrogated the privilege against self-incrimination. He did challenge the conclusion that the principle referred to had any role or any significant role in the construction of 3LA. He says it abrogates the provision, but it's not really relevant, said the AFP's Commissioner. So that's the argument. So Justice Bizanco in the full court turns now to consider the text, context and purpose of section 3 capital L capital A. This is not a case where there is a particular piece of text which is capable of alternative constructions, and the court must determine which construction is the correct one. Mr. Lupino's submission is that a requirement that the information or assistance be provided, be identified in the order, is inherent in 3LA. The Commissioner's contention is that Mr. Lupino asked the court to read into this section a condition which must be complied with, rather like the conditions set out in section 3LA subsection 4. On either approach, matters of context rather than a specific piece of text in this section are of first importance. So Justice Bizanco is saying, yeah, okay, the privilege against self-incrimination and the principle of legality will come into play if the text of a provision is ambiguous, but in this case we're arguing about other things, not the wording of section 3LA for the most part, right? We're not saying, oh, does it abrogate the common law right presumption against self-incrimination? Oh, it could do. It could. No, it does, right? We're just trying to work out. That's not the issue in front of them. So Bizanco goes on. I now turn to consider the text, context, and purpose. This is not a case. On either approach, matters of context rather than a specific piece of text are of importance. Sorry, I've repeated that chunk there. In conclusion, in my opinion, on the proper construction of 3LA, an order made under this section must describe the information or assistance to be provided, at least by reference to the type of information or assistance to be provided. It's not sufficient to describe the information or assistance by reference to the statutory words in section 3LA. So what's emerged is Justice Bezenko in the full court agreed with Justice White that the magistrate Fisher's order to Daniel Lupino was vague. It wasn't specific. So it emerged that the order had been signed and stamped with the seal of the court, but not really modified, by the magistrate. And the order, as applied for by the AFP, was quite vague as to what actually they wanted. Just wanted access to the phone. And Justice Bezenko agreed with Justice White that this was unsatisfactory. However, on another aspect of its vagueness which bothered Justice White was about a computer versus the computer. And Justice Bezenko says, does it make any difference that there were 2 other devices seized? In my opinion, it does not. It is clear that Mr. Lupino was aware of the computer or data storage device which was referred to in the Section 3LA order. During the conversation surrounding the execution of the Section 3E search warrant, 2 mobile phones and a laptop were seized. Mr. Lupino was asked whether there was a PIN or a password for the gold Samsung, to which his response was no comment. Mr. Lupino willingly supplied the passport to the laptop, and he volunteered information to the effect that the Samsung mobile phone did not require a password. It is clear, that was the one in the order box, it's clear that when Section 3LA order was served on Mr. Lupino 30th of August, he was advised by Sergeant Booth that the order related to the gold Samsung phone. He told Sergeant Booth he did not know the password to the phone. He didn't even deny it was his phone. He just described the phone as some gold thing. And he was asked whether he knew what type of phone. He said, and you said, well, you said it was an Samsung. And when they asked him if he used this before, he said he had not. Okay, so Justice Bezenko here is saying there was some vagueness in Magistrate Fisher's order, which was problematic, that it was talking about a device, the device, but it didn't really matter that the gold Samsung phone wasn't specifically referred to, because it was made clear to Lupino that that's what they wanted access to. So let's not get bogged down in that technicality, and I think that's probably. So what about whether it is a computer or a data storage device for the purposes of Section 3, capital L, capital A? Well, the primary judge says the definition of a data storage device is capable of encompassing a range of storage media, including DVDs, CDs, USB drives, and computer services, and it may well encompass other forms of storage media. His Honour said that the term did not seem apt to encompass a mobile phone, and he considered that there was nothing in the legislative history, the explanatory memoranda, or the second reading speech which suggests that the term was intended to encompass mobile phones. His Honour considered that mobile phones have been so ubiquitous for so long that it was natural to expect, had the Parliament intended that Section 3LA should extend to mobile phones, it would have been obvious for it to have said so. Just as we've explored. So Justice Bezenko is setting out Justice White's argument here about the definition, and then really goes on. The definition of a smartphone in the Macquarie Dictionary is as follows: a mobile phone with access to the internet and the functionality of a personal computer. In my respectful opinion, there is no reason not to apply the words computer and data storage device. The principle that Parliament intended the text to be regarded as ambulatory. All right, now this is a term I don't think we've come across before, but it's a term that judges use in statutory interpretation cases from time to time, and we've got some Chief Justice Gleeson using it there, Barwick, and there's some examples of ambulatory interpretation of words. So the idea is that there are certain words used in acts which, to preserve their purpose, to make sure they address the mischief that they are intended to address, they need to have a meaning that evolves over time. So ambulatory, think of it as an ambulance racing through the traffic to keep up, to get to the the victim. So it's moving, right? It's not static, it's not fixed, it's not rigid, it's plastic, it's ambulatory, it can move. And so the word's meaning evolves over time. So ambulatory just means moving, right? So Parliament uses some terms and their meaning evolves over time. And in this case, he's saying there's no reason to think in this case that Parliament intended that the terms computer and data storage device were to be restricted to devices denoted by those words at the time they were introduced. All right? So they've evolved. So likewise, your television, a television in the 1980s, they didn't have remote controls. Then they did have remotes and you didn't have to get up off your couch to change the channel. And now we've got smart TVs where you can watch YouTube. So, if you think about a TV in the 80s and 90s, you could have said, oh, that's a device that receives fixed signals from an aerial, from the ABC tower when it was analog, and then in 2000 and blah, it went digital, and now they're Wi-Fi and smart, connected to the internet. So a TV has evolved, but it's still a television, isn't it? So an ambulatory interpretation of the word television in an old text statute would now look at a modern TV and go, yeah, that's still a TV, just because it no longer receives fixed analog signals from a tower, TV broadcasting tower. It's still a television. All right. Paragraph 169, the gold Samsung phone was a computer, as that term is used in section 3LA. It might also be characterized as a data storage device. You take photos, videos, it's stored on there, isn't it? There was no need for the magistrate to have evidence on the point, and there was no error in the magistrate forming the required state of satisfaction in relation to this issue. Now, you may remember under section 3LA, to issue the order, the magistrate had to be satisfied, didn't he? Had various things. Remember that there was Lupino was guilty or likely reasonable grounds to think he's committed an offence, and that there was evidence in the machine, the data storage device, that would help substantiate that offence. And as Bazanko says, no, it is a computer. That term's evolved, and he concludes what Justice Wright was wrong on that. That he's got it just about wrong on everything, except that the magistrate's order did not sufficiently specify the kind of assistance that Lupino was required to render to the police. And Justice Bazanko said that was critical, so that the vague order meant that Justice Wright was still correct to invalidate the magistrate's order. So we're clear on that? Bazanko says, White's right about the vagueness, and on that ground it's invalid, but White's incorrect about it not being a computer, etc. However, Justice Bazanko wasn't on the majority on this. So Justices Wigney and Abraham, they agreed with Justice Bazanko on almost everything, but they also thought White was wrong about the vagueness of the order. And they said that the effect of the Lupino submission, as articulated by the respondent in oral submissions, is that this satisfaction had to relate to a particular application on that computer or data storage device, which contains the evidential material. So, was it WhatsApp messages? Was it video in WhatsApp? Was that the evidence that they wanted to get out? And that the satisfaction in respect to accessing the device itself, like the whole phone's data, was insufficient. As explained below, the text of the provision, considered in its context and given its purpose, does not support that conclusion. So Lupino's team was saying, argued before the full federal court, that Magistrate Fisher should have specified access to a particular app on the phone or the particular kind of material, but their honours Justice Wigney and Abraham disagreed with that submission. They go on that they said the principle of legality is a principle of construction directed to the overarching objective of giving the words of a statutory provision the meaning which the legislature is taken to have intended them to have. Have a look at Lacey and the Attorney General. Even if the effect or operation of an order under Section 3LA may somehow encroach upon the privilege against self-incrimination, which may be questionable, Section 3LA nevertheless manifests the necessary intention to exclude the operation of the principle by unambiguously requiring the provision of assistance and by criminalising non-compliance with the provision. The legislator in doing so has struck the balance between the competing interests of individual rights and the public interest in enforcing compliance with the provisions relating to the investigation of crime. All right, so do you remember we said in cases like Coco and the Queen or Potter and Minahan, they said in those principles of legality cases that if the necessary intention is expressly clear in the legislation, do you remember in the UK court said, look, they've got to squarely front up and abrogate these common law rights, and then they have to deal with the political consequences of that. So this is another example, well, this is an example of a statutory provision riding roughshod over traditional common law freedoms and rights that the common law is trying to protect, but it can only do so much. And if there's clear intention of Parliament and it's expressly clear in the legislation, it's unambiguous, then this principle has no application. And that's what Justices Wigney and Abraham are saying in the case here. All right, and it's back to the separation of powers, isn't it? Back to your Venn diagram, back to parliamentary sovereignty. Okay? The legislature, in doing so, they say, struck the balance between these competing interests of individual rights and the public. So it's Parliament's job to consider whether this privilege against self-incrimination should be displaced here, and it did. Yes, it's Parliament's job to strike that balance, and then it's the court's job to go along with that essentially and support the will of the Parliament. And their honour's conclusion about how specific the order was, they said, we're unable to accept the respondent's construction of Section 3 LA is reasonably open in the application of ordinary principles of statutory construction. There is no constructional choice, which might be said to give rise to the application of the principle of legality. And they also said that the text, considered in its context and given its purpose, does not support the construction adopted by the primary judge. Justice White, remember? So the Commission has established that the primary judge erred in this regard. It follows that the Commissioner has established that the primary judge erred in concluding the order was invalid because it did not identify the particular information or assistance required to be provided by the respondent. So in the end, Justices Wigney and Abraham also addressed this issue of the computer or a data storage device, and they agreed with Justice Bozanko that even if the order should have specified the particular computer, that does not invalidate the order in circumstances where the respondent plainly knew that the information requested was in relation to the gold Samsung phone. And as explained by Bazanko in Ground 5, so that's the specific bit of His Honour Justice Bazanko's judgment, that device is a computer or data storage device within Section 3LA. They are agreeing with the ambulatory interpretation of that word, that it's an active word and it evolves with time and technological advancements. So they agree with Bazanko. So basically they've disagreed with Justice White on all of his findings against the AFP and Magistrate Fisher's findings, and since they form the majority on a full court bench, Justice White's order was overturned. So look, we need to think about these different approaches, and that's what we're going to be doing in class this week once we get through our presentations, and think about whether the full federal court's ruling is the last word on this matter. So what could happen next? Well, obviously it could be appealed again, but so far there's no indication of a pending High Court appeal. And what do you think, even if it went to the High Court, what do you think the nation's highest court would be more likely to agree with Wigney and Abraham or with White? And I'd like you to consider that we've got experienced judges, we've got White, Bazanko, Wigney, Abraham. They all took different approaches. Obviously the justices in the full court of appeal there, the full court of the federal court, were closer to one another than to Justice White, but they all took different approaches to the statutory interpretation, even though they were applying the kinds of principles that we've talked about. So I would urge you to reflect on the fact that there's not necessarily one correct way. There's more than one way to climb a mountain, all right, to interpret a provision like 3LA. But obviously we take our guidance from the most senior courts, and in this case it's the full court of the federal court. Now, if it were to be appealed again, I'd like you to reflect on the case of Smethurst and the AFP Commissioner, which is a 2020 High Court case. And the High Court in that case, by majority, refused to grant journalist Annika Smethurst, pictured here, who was working for News Limited at the time, has since moved to The Age, I think, in order to destroy or return data that was seized from her home, including on her phone, even though the warrant under which the AFP obtained the data was held to be invalid. So they weighed up the purpose or the value of investigating crime. In this case, she was alleged to have received leaks relating to defense matters illegally. And as you can imagine, there's been a significant controversy over this case because receiving, obviously leaking information is a crime for a very long time, it's espionage, right? It's a big deal, leaking state secrets. But receiving that sort of information as a journalist has led to, well, in this case, the AFP raiding the journalist's premises, including Annika Smethurst's house. The AFP, remember the ABC's head office got raided? So the Australian Broadcasting Corporation. So the High Court said, well, in the interest of prosecuting a crime, even a crime of maintaining government secrecy, which many people believe goes too far. I mean, look at the Julian Assange, still in jail for receiving leaked data and publishing it. was important enough that they wouldn't invalidate a warrant that the AFP used to seize Miss Medhurst's information, her data. But even invalidating that warrant, eventually they did, wasn't enough though for the High Court to say, well, all right, now the AFP has got to destroy or give back the relevant data because it was obtained, even though the warrant didn't stack up. The balance of individual rights versus the public's right in investigating these sorts of crimes, federal crimes, are such that we're going to strike the balance and find on behalf of the Australian Federal Police. So it's an interesting and controversial judgment, Smethurst and the Commissioner, and I think it also provides some kind of pointer to the approach that may be taken were the Lupino case to be appealed to the High Court. All right, that's it for topic 10. Thanks for listening. I'll see you next time. Thanks.